Oh, I'm waiting.
Recording in progress.
Yeah, again, good morning. Thank all of you for attending. But we got a full board and Ms. Rawson's on Zoom, so, have a nice meeting. I'll go ahead and call this meeting of Arkansas State Plant Board to order. And, first thing we'll do is just introductions, and we'll start with the board here at the table. Go ahead, Mr. Thorne.
Robert Thorne from Marion, Arkansas.
Matt Miles from McGee, Arkansas.
Sammy Angel, Chico County.
Nathan Reed from Marietta, Arkansas.
John Beerbaum, Chico County.
Travis Center from Wilson, Arkansas.
Nathan Slayton representing the Division of Agriculture in Fayetteville. Reynold Meyer from Eudora, Arkansas, representing Arkansas Cattlemen. George Duckland from Arkansas County.
Grant Department of Agriculture. Brenda Reynolds, Department of Ag. Krista Moulter, Department of Agriculture. Linda Levy, Department of Ag.
Kevin Corth, the University of Arkansas Division of Ag.
Kyle Balls from Randolph County. Garrett Frost, Marietta, Arkansas.
David Gamble, farmer, Mississippi County, representing corn, wheat, feed grains.
David Wallace Jr., Crawfordsville, Arkansas, Crittenden County.
Bruce Alford, Louisville, Arkansas, representing Florida.
Sam Stuckey, Clarkdale, Arkansas, Crittenden County, representing Cotton College.
Ms. Rawson.
Yes, Robin Ralston, Atkins, Arkansas, representing wholesale retail fuel.
Thank you. I'm Matthew Marsh, from Little Rock. I represent Arkansas Rice Growers. That's the board. I think we got a full board in attendance. So we'll go around the room and let everyone introduce themselves. Andrew.
Andrew Grubmeyer with the Ag Council of Arkansas.
Linda Alford, Louisville, Arkansas. Jennifer Hadlock, visitor from Phillips County.
Lucas Hargraves, Consultant. Hi Davis, Senator John Bozen,
Brady Harrell, Health Partner. Regina Coleman, Arkansas Vulnerable Eradication Foundation.
Otis Howe with the Arkansas Crop Protection Association.
Keith Driggs with Arkansas Agricultural Consultants Association.
Christina Leroy, Arkansas Department. Amy Lyman, Arkansas Department of Agriculture.
Kelly Robbins, Arkansas Rice Federation. Steve Farron, Arkansas Oil Marketers. Bill Black, Arkansas Department of Agriculture.
I'm Scott Brady, Arkansas Department of Ag. Most of y'all know me. And while I had the floor, Mr. Chairman, I want to give my standard Zoom little speech before we get started too far into the meeting. You've all heard it and you all know it, but I like to do it every time. So the owl sitting at the middle of the table catches audio and video. It focuses on audio, so just be mindful. Any side conversations that might zoom right into you. Everything's recorded. It can even pick up stuff in the back of the room. So everybody just be mindful of side conversations, what you say. Everything is going to be video and audio recorded. So thank you.
Tim Chester, Department of Agriculture, weights and measures.
Nick Sawyer, Department of Agriculture.
Lee Gibson, Department of Agriculture.
Susie Nichols, Department of Agriculture.
That's everyone. Thank you all. We'll continue on. I think the second item on our agenda is we have the minutes of the December 5th board meeting. I think the board's had a chance to review them. Any comments or changes need to be made?
Make motion to approve.
Second.
And a second to accept the minutes as written. Any discussion? Hearing none, all those in favor, say aye.
Aye.
Opposed? Motion carried. Thank you. Next thing, we got the pest control section, and Mr. Alford's got us a report, I think.
I do. We had a meeting, February the 12th of 24, and Bruce Alford, Kyle Ball, Travis Center, John Beerbaum, Garrett Frost, and Matthew Marsh was there, and Matt Miles was also there. Two informal resolution agreements of the pest control incidents were presented by staff. Case file 24081, True Green major level violation to agent making a pesticide application like a PPE. Agreed to an informal resolution of $300. That's attachment A1. Case file 24113, Legacy termite and pest control major levels of violation due to agent making a pesticide application with lack of PPE. Agreed to informal resolution of $300. The committee voted unanimously to present the two resolution agreements to the plant board for final approval. I would like to make a motion to approve the pest control committee recommendation to accept the two statement settlement agreement resolution.
I'll see.
Got a motion and a second to accept the pest control recommendation on the settlement agreements. Any questions or comments? Hearing none, all those in favor, say aye.
Aye.
Opposed? Motion carried.
I'd also like to make a motion to accept the minutes from the February 24 pest control committee meeting as attachment 2A.
Second.
Got a motion and a second to accept the minutes of the settlement control committee meeting. Any questions? Comments? All those in favor, say aye.
Aye.
Opposed? Motion carried.
Pest control examination report. I'd like to make a motion to accept the pest control examination results from the month of December 23rd through February 24th, attachment 3.
Second.
Got a motion and a second to accept the pest control examination results. Any questions on those or comments? Hearing none, all those in favor, signal by saying aye.
Aye.
Opposed? Motion carried.
That's a good motion.
Thank you. Okay. Next thing, we got the pesticide section report, and we didn't have a committee meeting, but Ms. Susie has embedded pesticide collection report.
Mr. Chairman, I don't have much of an update. I'm just gonna pass out the upcoming collections to everybody. This is what's proposed. This is always dependent upon funding. We will not be having a collection this spring due to the large collection we had last fall. The upcoming counties projected right now for fall 2024 are Washington, Carroll, Madison, Benton, Boone, Newton, Marion, and Baxter. And for spring of 2025, we're looking at Lee, Monroe, Phillips, Woodruff, and St. Francis. And just a reminder, we rotate throughout the state. Funding looks good. We may add some. We may do some satellite collections back up in northeast Arkansas. But we'll keep you posted when we have dates actually set. We'll put them on the website and I'll let y'all know. That's all I've got.
Planning funding is good for these things. Can you go ahead with those?
We think so. Okay, so we reevaluate that constantly because we're constantly bringing in money through the product registration program. But yeah, we keep an eye on that. Thanks.
Right. Next thing, we can go through the Bureau of Standards Committee report, Ms. Lawson, it's on Zoom, so, whenever you're ready, Ms. Lawson.
Since I'm not there, I've asked Nick if he will present that.
Great.
Thank you, Mr. Chairman. The Bureau of Standards Committee met on February 15th, 2024. Staff presented 47 civil penalties to the committee for review and recommendation to the board. All the violations are included in the paperwork you have under attachment 1. Within attachment 1, there are 4 tables. The table 1 consists of 23 violations for expired or no decals. Out of these 23, 18 are first offenses, 4 second offense, and 1 third offense. In table 2, there are 10 violations for misrepresentation of pricing, of which 6 first offense, 2 second offense, 1 third offense, and the last one is the 10th offense. In table 3, there are 13 for water contamination, and all of these 13 violations were first offenses. Table 4 has 1 offense for flashpoint failure. I would like to make a motion to approve the Bureau of Standards Committee to accept the civil penalty actions.
I'll second.
I'll make the motion to approve the civil penalty actions.
Who made the second?
Second, Mr. Miles. Well, he did, but I think that has to be made a motion, just for point of clarity. I'll make the motion, Mr. Miles second. Any discussion or questions for Nick on the civil penalty? Hearing none, all those in favor of approving the civil penalty, signify by saying aye.
Aye.
Opposed? Motion carries.
Concludes my report, Mr. Chairman.
Thank you, Nick. And that gets us through the Bureau of Standards Committee report.
Mr. Morris.
Yes.
I want somebody to make a motion to accept the minutes for February 15th, 2024 Bureau of Standards Committee.
Second.
Got a motion and a second to accept the minutes from the Bureau of Standards Committee. All those in favor, signify by saying aye. Aye. Opposed? Motion carries. Thank you, Nick. Next, Mr. Sam has us a boll weevil committee report.
Okay, the Boll Weevil Committee, met on, February 7th. In attendance was Chairman, Joe Menser, Greg Garner, Denton Phelps, Pace Hensley, Randy Stiles, myself, and Travis Center was under the action. We met and saw the budget was presented, and it was, the direct expense was, 71,629.78. And there's an itemized list, and the itemized list of overhead expenses was 171,552.76 for a total of 242,182.54. And the board, approved the budget, and I'd like to, make a motion that, the budget be approved.
Got a motion from Mr. Second. Second offer to approve the boll weevil budget. Questions, comments?
Just for clarification, and Virginia can help me out here. I think what Mr. Stuckey was quoting you all was the Delta invoice. And, for a little background, when the boll weevil eradication foundation and program was established, I don't remember the exact year, but there was an area we refer to as a Delta zone that did not come into the program. They had to be legally, legislatively brought in years later. And with that legislation, it required a little more plant board oversight than the other zones. And it requires that the plant board review and approve the invoice specific for that zone every year. And that's what we're doing. That's what they did. They presented that to the boll weevil subcommittee, and now we're presenting that to you all for approval. Any questions about the invoice or anything? Yes, sir.
Is this something that's gonna be ongoing, or since this is all within the realm of, how is this gonna progress?
I think it will be ongoing for the immediate future. At some point, they may come back maybe in 2025 and tweak that legislation. I don't know, but as of now, it is still required, as I understand it. So we just want to make sure that, you know, the plant board sees and gets a look at that invoice. And if you have any questions, we're here to answer it. The program, you know, I'll just tell you, the program's in excellent shape. And it has been for several years now. And they're even doing the last 3, 4, 5 years, they've done rebates back to growers. And any of you that grow cotton, you know that. So.
Quick question on the invoice. I just want to make sure that we're putting this in for the record. Both of these invoices say direct expense. I'm assuming the second one, 171, should be overhead.
I'm going to refer to Regina.
Okay, I just want, because they look like they could be duplicates that are different, and I figured you don't stick it in a file to look back at later if they do.
I'll make that correction.
Okay, no problem. Any more questions involving the invoice? Okay. Thank you.
Also during the meetings, did we go?
Well, I guess, yeah, we've got a motion second. We're talking about the Delta invoice and that is what we're voting on. So all those in favor of accepting the Delta invoice from the Boll Weevil eradication program, signify by saying aye.
Aye.
Those opposed, motion carries.
And then, during the meeting, the recommendation was again for, $3 an acre for the upcoming year, which, and a dollar rebate from 2023. And, so I guess I would like to make a motion, we approve the minutes and those, do I need to approve those charges separately or can it be approve those separately? Okay.
We should.
Yeah, $3 an acre was what was, voted on by the committee and, with a dollar rebate for the previous year.
You got a motion to accept the committee's recommendation of
Yes.
$3
That's my
an acre, assessment and a dollar rebate for the 2023 crop.
And in the $3 an acre for the 24 crop, it's open for a potential rebate in the future, but we can declare that now it's too early to do that.
Okay. You got a second. Got a motion to accept the committee's recommendation for the 2024 assessment of $3 and the 2023 rebate of $1 back to the growers. Got a motion and a second. Any questions, comments on the motion? Hearing none. All those in favor, signify by saying aye.
Aye.
Opposed? Motion carried.
And I would like to make a motion to approve the minutes of the board meeting, the committee meeting.
Second.
Got a motion and a second to accept the Boll Weevil committee meeting minutes. All those in favor, signify by saying aye.
Aye.
Those opposed?
I've got a question for Regina. Do I need to have a motion for the, and Scott, for the full budget?
We will review the budget and then we'll have our July meeting with that.
Okay.
Representing folks.
Right, okay. I guess that's all.
Yeah, thank you, Mr. Sam. We'll, got all that cleared, on the Boll Weevil eradication program. Thank you very much. The last thing on our agenda, we've got Ms. Bridget Rollins, on Zoom. She's from the National Ag Law Center. Some of you may have heard her speak before on the, ESA and, she's here to kind of give us an update on that, where we think that may be headed. And then just maybe some, if we have any questions or update on where the, dicamba ruling is. No, that's kind of, that's not been out of our, it's been out of our hands, but I'm sure if you're like me, you get a lot of questions about where it is, what's going to happen, and maybe Bridget can give us a little insight so we can at least have some answers when we get those phone calls. So she's, here on Zoom, and Bridget, I'll let you, have the floor.
Thank you. Can you all hear me okay?
Yeah, yes.
Good, good. Good morning, everyone. Yes, my name is Bridget Rollins. I'm an attorney here with the National Agricultural Law Center. I've actually prepared a few slides. If that's all right, I could go ahead and share my screen.
Yes.
Great.
Right. Let me go ahead and get that set up. All right, and then let me start this. So yes, I'm going to go ahead and share with you all a little bit about where we are with the dicamba ruling, sort of what we know, what we don't know. I guess sort of the maybe good news there is that, you know, it's as you said, out of our hands. This is sort of what EPA has said, what the courts have said. So, you know, as far as what we're able to do, it's sort of like, well, this is where we're at. So we'll go through a little bit of that and then talk again about the sort of emerging ESA FIFRA issue. For those of you who were able to join us in December, I believe is the last time I visited and spoke with you all. Some of this is going to be a little bit of review, but maybe for those of you who are a little unclear about exactly what EPA is proposing, this will be some good information. And then we'll just walk through some updates, mostly just updates to deadlines, but that's, you know, never a bad thing to be aware of. So very quick.
Bridget,
Yes.
this is Nathan. We're seeing your speaker.
Oh my goodness. Of course. I have yet to figure out how to actually square that circle so that when I share it the first time, it just shows the presentation. Is that better?
Yes.
Oh my goodness. Thank you. It's so funny how we've been using Zoom all consistently for so many years now. And it's still like, how does this thing work? We'll figure it out one day. Very briefly, for those of you who aren't as familiar with the National Ag Law Center, you know, we're part of the Division of Ag, and it's our job to provide up-to-date resources on what agricultural law is doing and saying and how it's impacting people on the ground. So we're here to be a resource for you all to do stuff like this. Yeah, we're here for you. So I am actually going to start with dicamba and then move on to ESA FIFRA. I figure we'll get the slightly easier one out of the way first. So very briefly, again, for most of you, this is probably a bit of a recap, but February 6th, the federal court in Arizona went ahead, they issued that ruling vacating over-the-top registration of kind of those three big over-the-top dicamba products, XtendiMax, Ingenia, and Tabium. As a quick reminder, all three of these were registered for over-the-top use through the 2025 growing season. So, you know, if this order had not gone through, we would have had these products at least through next year's growing season. But following this decision, these products are unavailable. EPA has issued already their sort of formal cancellation order allowing use of existing stocks. For this 2024 growing season. I'll go into more detail on what that order says. I think that's kind of going to be the big, you know, the most sort of practical thing to know going into this growing season is what that order allows and what it doesn't allow. But just as a brief headline, it's allowing the use of existing stocks during the 2024 growing season, with existing stocks defined as products that were labeled, packaged, and released for shipment prior to February 6th. And then, yeah, as a brief reminder, again, for most of you, this is not, you know, new news, but this is the second time that a court has vacated over-the-top use of dicamba. I'm sure you all remember 2020, the Ninth Circuit issued a very similar ruling, once again, vacating over-the-top use. Just a quick recap for sort of how we got to this particular situation, right? As I said, in 2020, the Ninth Circuit vacated what was then the current label allowing over-the-top use of dicamba. That case was a little different from this current one. The Ninth Circuit case from 2020 was based purely on substantive issues. The Ninth Circuit found that EPA had violated FIFRA when it registered those products for over-the-top use, kind of finding that EPA didn't fully consider all of the risks and consequences of registering over-the-top use of dicamba. They cited, you know, underreported amount of, acreage planted with dicamba resistant seeds. The court also sort of said that EPA didn't fully consider the amount of dicamba damage that had occurred during sort of the previous growing seasons. And they also cited, EPA's failure to consider sort of economic and social risks as well. So that decision was issued in June of 2020. Before the end of the year, EPA had re-registered over the top dicamba. So that's the current registration that was before the court in Arizona. That registration was sort of that 5-year registration. It would have allowed over the top dicamba use from sort of the 2021 growing season through the 2025 growing season. We saw increased use restrictions on that label, right? That's when we got the federal cutoff label. That's when we also saw some increased buffer zones and some additional restrictions on when those products could be applied, sort of attempting to kind of address the substantive issues raised by the Ninth Circuit. And then very expectedly, we got a lawsuit challenging sort of the new registration, right? It's the same plaintiffs as the 2020 case. This is actually the third time those particular plaintiffs have challenged a dicamba over the top registration. And they made, once again, the same claims that EPA had violated FIFRA and also that EPA had violated the Endangered Species Act by not doing sort of that mandatory Section 7 consultation that all federal agencies are required to do under the ESA. So just again, a quick recap to sort of how we got where we are. And then, yeah, the court's decision, right? Again, this came out February 6th. If you were anything like me, your phone was suddenly blowing up in the middle of the day with news of this decision. And this was a little different than the Ninth Circuit decision, which is, kind of good and bad. It sort of means that if EPA is going to try to sort of redress this issue, they now have sort of a different angle that they're going to be looking at it from. But essentially, I mean, kind of the big headline is that the court revoked the registration. So over the top dicamba registration for those 3 products has been completely overturned. And like I said, this is a slightly different decision than the Ninth Circuit decision. The Ninth Circuit was very substantive, right? They were focusing on, did EPA sort of meet this substantive portion of its FIFRA sort of requirements? This was a procedural decision. So here the court found that EPA failed to follow mandatory procedures for registering this product. Very specifically, the type of registration that EPA had done to allow what was at that time a new use of dicamba, because there were no over-the-top registrations for dicamba following the 2020 decision. So even though, this wasn't a new use in the sense that we'd had over-the-top dicamba registered before, it was legally speaking a new use under FIFRA because there were no products registered for over-the-top use at that time. And essentially when EPA registers a new use under FIFRA, the law mandates that they have a period of public notice and comment. EPA didn't do that. They had issued their sort of 2020 re-registration decision without notice and comment. Again, they were trying to be expedient, but they didn't do this particular process. And that's what the court dinged them for. The court said, you are supposed to have gone through this process. You didn't follow this mandated procedure. So we are revoking the registration, which is good for EPA to know, right? If they wanted to try to re-register these products in an attempt to sort of, address the issue identified by the court, they have a pretty clear pathway, right? They need to go ahead and do sort of this procedural thing that they didn't do. Of course, the downside to that is this court case also raised substantive arguments that the court didn't reach. So I think it's probably fair to say that should EPA pursue sort of re-registering these products, they are going to get sued again, probably by the same plaintiffs, probably with the exact same arguments, and those substantive issues are still out there. Again, that's a little, pie in the sky, a little sort of outside of the very practical impacts of this decision, but I think maybe important to kind of keep in mind as we sort of think about what could or could not happen going forward. So as I mentioned, EPA has issued its existing stocks order. So this came out on February 14th. Happy Valentine's Day to all of us. Little Valentine's treat from EPA, this existing stocks order. And this order did a couple of different things. So first, this order is very, very clear that, after February 6th, as of February 6th, 2024, there are no dicamba products registered under FIFRA for over-the-top use. And EPA was very clear that going forward, right, over-the-top use of dicamba will not be allowed, and that any use of existing stocks of these three products, right, XtendiMax, Tabium, and oh goodness, and the other one, Ingenio, that any use of the existing stocks of those products will need to conform to the labeling on those products. All off-label use will be prohibited. EPA is very clear on that. And part of why they have to be so clear on that in the existing stocks order is a bit of a quirk of FIFRA, where EPA does have to specify that these uses are canceled and all off-label use going forward will be prohibited. So again, and the other thing this order does is allow existing stocks. And as I said, those existing stocks are defined as those stocks of previously registered pesticide products that are currently in the United States and were packaged, labeled, and released for shipment prior to February 6, 2024. So those are the requirements, that the products had to be in the US and then packaged, labeled, and released for shipment before February 6th. And the order also clarifies that a product has been released for shipment when the producer has packaged and labeled it in a manner in which it will be distributed or sold, or has stored it in an area where finished products are ordinarily held for shipment. So these products needed to be, right, packaged, labeled, ready for sale, and really outside of the manufacturer's control. And then finally, this order set up cutoff dates for both the sale and then use of existing stocks of these three dicamba products. So certainly that's going to be very important to be aware of. Not only is there a cutoff date for use, but there is a cutoff date for sale of these products. And these are all sort of laid out by state. In Arkansas, we're sort of been grouped in with, there's like 15 or so states that have these same cutoff dates. So we're in the group where the cutoff dates for sale are May 31st for any of the over-the-top dicamba that's meant to be used with soybeans, and then June 30th for any of the over-the-top dicamba that's meant to be used with cotton. So those are the cutoff dates for sale, May 31st, for dicamba that's going to be used with soybeans, June 30th for dicamba that would be used with cotton. And then the cutoff date for use is June 30th for dicamba used in soybeans, and July 30th for dicamba used with cotton, which models the cutoff dates on the federal labels. So I think kind of the big thing to know, I mean, one, obviously the cutoff date for use, although that is those are the federal cutoff dates, but it's those cutoff dates for sale that I think we're going to need to be very clear on. And then just finally, kind of taking a look ahead, what might happen with this. It's possible that EPA could appeal this decision, but that's maybe not necessarily going to be so cut and dry. Arizona is sort of within the Ninth Circuit. So if EPA appeals this decision, they would be appealing it up to the Ninth Circuit, which again, overturned the dicamba label in 2020. So this could potentially be, a more difficult court for EPA to be in front of. They've got 60 days from the ruling, so 60 days from February 6th to decide whether they're going to appeal or not. I have not seen any indication that EPA is intending to appeal it yet, but they still have, by my count, another almost 30 days or slightly over 30 days. So that could be in the works. I think the other thing that we have to ask ourselves, not just what is the future of this litigation, but going forward, could we see any future registrations? I mentioned this case from Arizona was purely procedural. So, in theory, EPA could perhaps resolve just this court's issues by sort of re-registering the products and allowing, that notice and comment time. But like I mentioned, the plaintiffs have pretty consistently in their lawsuits raised these substantive claims that it's hard to say whether or not EPA has really addressed. I think the Endangered Species Act claims are of concern for EPA and for the pesticide manufacturers. Again, one of the things that the ESA does is require any federal agency, when they're taking an agency action, which registering a pesticide absolutely falls into that category, they need to engage in Section 7 consultation. So EPA needs to work with Fish and Wildlife Service to make sure that their action won't kind of contribute significantly to the possibility that a species could go extinct. That consultation process can take quite a bit of time in and of itself. You know, when you've got a pesticide that's registered across over 30 states with numerous different ecosystems in those states, numerous different species, just that can take some time. So I think it's, you know, you never know what's going to happen. My crystal ball, alas, is broken most days, but I think it's probably fair to say that if EPA is going to re-register this in such a way that they could have a registration decision that would hold up in court, it might take them some time to really comply, not just with the procedural issues that were raised in this Arizona decision, but it could take quite a bit of time for them to, you know, really handle those substantive issues as well. And then, of course, there's always the lingering question of, will the registrants have the appetite to pursue another registration? That one I can't answer, but I think is worth considering. So that's kind of the update on dicamba. I think I'll go ahead and pause now in case anyone has any specific questions on just this before I move on to ESA FIFRA.
Hey Bridget, this is Scott. I do want to make a couple comments on label requirements versus state-specific rules.
Yes.
I want to remind everybody that in Arkansas, we do have state-specific regulations that go a little above and beyond the label. And as I understand it, they are still recognized by EPA. One specifically is our cutoff date is June 30 for everything, beans and cotton. And then we have our own specific buffers, which go far beyond the label. We have 1 mile, half-mile, and quarter-mile buffers, depending on the adjacent crops or plant life. And then we have some glyphosate mixing regulations. So just so everybody's clear, our state rules still are in effect, and they do still apply to these 3 over-the-top products.
Yes.
As far as the cutoff date for purchasing, we don't address that. So I'm going to say right now off the top of my head, being able to buy for cotton right up to June 30, we don't address that. So I'm going to say it's still in play, but our cutoff is June 30 for cotton and beans.
Yes, thank you, Scott. I think that's so important to keep in mind. And yes, that in Arkansas, right, those Arkansas specific rules are still in place, at least as far as this goes. And yeah, that's going to be kind of an interesting quirk that sale could be allowed for cotton up to June 30, but use is going to end June 30. So
Correct.
Maybe remind, you know, if anyone who comes to you with questions that they should plan accordingly. All right.
Quick question for you. If EPA decides not to appeal, but to go through the re-registration process, do they have to restart everything, or can they just do the notice and comment that they didn't do last time?
I mean, so when an agent or when EPA is working to register a pesticide, right, they are relying on usually a lot of data submitted by the registrants, a lot of data maybe even submitted by, you know, research universities like ours. So presumably EPA still has all that data, still has all of that to rely on. So they should be able to, you know, not necessarily have to start from scratch there. They might need to start not fully from scratch, but, you know, a little bit from scratch on putting together maybe some stuff for the administrative record. So if they're going to maybe put in a little bit more effort to sort of expand and clarify why they're making some decisions, they might need to start sort of from scratch there. But no, I don't think that they would have to start completely as though this were an utterly new thing they were considering, right? They still have quite a bit of data, quite a bit of, you know, their own research and reasoning. I don't necessarily think that they'll I would be somewhat surprised if EPA just put forward the same registration, no updates, no changes, just putting it up for public notice and comment. They could choose to do that. I would personally be surprised if they didn't do any kind of tweaking at all. But so I think to answer your question, no, they don't have to start completely over. They certainly have quite a big reservoir of data and administrative records to pull from, but I suspect that they will at least go through and make a few changes, refine some things, just again, to kind of try to make a more judicially defensible label.
Thank you.
You're welcome.
Got a couple questions, Bridget, Matthew.
Mhm.
So if the EPA doesn't appeal, or if they do appeal, or if they go through re-registering the product, what's the timeline on that look like? Is there, can it be pulled off by fall?
That is
Are
a
we-
really good question. I'm not personally confident that it will be done by this year. I have heard a number of different things on the timeline. I think right now, the most I can say is that it's very uncertain. I had the opportunity to speak with a representative from BASF, which is the registrant and manufacturer of Ingenia. And they told me, and this was right after the decision was issued, we had no existing stocks order at that time, but the representative I spoke with said it's possible it could take even up to 3 years. And that's not factoring in whether or not EPA might do that ESA Section 7 consultation. So I think right now, without any further indication from the agency on what they're planning to do, it's hard to say, but I would not be shocked if this was a years-long process.
With either of their choices.
With either choice, yes, with either choice. And like I said, I could be wrong on that. I've heard some speculation that it could take significantly less time. I've heard some speculation that it could take more. I think right now, unfortunately, we just don't have enough information to make a really accurate prediction of what EPA is even planning to do, let alone how long it could take.
I've got a question. Is it possible that someone could challenge this existing stocks order rule and pull the rug out?
It certainly is. This was received a bit less attention, but back in 2020, EPA issued an existing stocks order then. That existing stocks order was actually challenged by the same plaintiffs that had brought these lawsuits to begin with. So they did challenge that. That didn't go anywhere for a couple of reasons. One, EPA is well within its authority to issue these existing stocks order. These are allowed and under FIFRA and are, arguably very legally necessary because they instruct, pesticide users and other state regulators on what to do with these existing stocks. Also, there's the timeline to consider, right? This order is allowing use of existing stocks, through July 31st in various different states, which sort of means that if this order was going to be challenged in any sort of successful way, you would have to expect a court to move really quickly to do anything that might result in the order being revoked. So it's possible this could get challenged. I'm not confident that challenge would go anywhere, both because, again, this is pretty well considered something within EPA's authority to do. And also the timeline for a court to consider the arguments and issue issue a ruling that would impact this order is very, very limited. And courts generally just don't move that quickly.
Thank you.
Mm-hmm.
Any other questions for Bridget on the dicamba ruling?
All right. Well, if there's no, yes.
Travis there. Exactly what is EPA's leeway on, existing stock orders or continued use timeframe? I mean, if this happened to take another product this happened to, what can EPA do? Can they say it's 2 years? Can they, you know, would that get challenged pretty quickly? You know, what are some of those leeways?
So that's a great question. I would say that probably 2 years, they're gonna be challenged, right? You know, you gotta consider that EPA is, not only are they sort of cabined by FIFRA, but they're also, right, cabined by what the court is allowing. Typically, when I've seen these existing stocks orders, they really only sort of plan through the end of the growing season. I think any longer, and EPA is certainly opening itself up to more legal challenges, and right, like, the longer an existing stocks order is allowed to go on, the more likely a legal challenge, one, could be brought, and then two, have time to make its way through the court system. Um, I would probably need to go kind of a little bit deeper into some of the FIFRA regulations to get a really good answer for you on sort of what EPA is and isn't allowed to do here. But in general, it's considered that EPA has the ability to issue an order directing how existing stocks should be used, how they should be disposed of, right? That's also part of what this order does, is sort of provide a pathway for what to do with, you know, if you're sort of left kind of holding on to dicamba products that you can't use, you know, this order then allows them also to be returned back to either EPA or the manufacturers. And like I said, typically when I've seen these orders, they really only go through the end of the growing season. But if that's something you would like to maybe dig into a little bit more, feel free to reach out to me. That's something I'd be happy to look more into for you.
Thank you, Bridget.
You're welcome. All right. Well, if there's no other questions, I'm going to move on to ESA FIFRA. And again, I'll put my contact information up at the end of this. So anyone, if a question comes to you later, if you think of something, feel free to reach out to me and I will do my best to answer it.
Thank you. We'll hold questions from the audience. We can contact Bridget. She's available. Okay, Bridget, go ahead.
All right. So ESA FIFRA, like I said, if you were at the meeting in December, you might have heard from me already on this, or maybe you've already got some familiarity with this issue. But if not, I'm going to provide a little bit of an overview and then kind of let you know, what we don't know. I'll give you a just quick kind of spoiler that right now we have more don't knows than knows. So, you know, kind of go figure there. But very broadly, this new ESA FIFRA policy is an attempt by EPA to better meet its Endangered Species Act responsibilities when taking actions under FIFRA. So I mentioned earlier, one of the things the Endangered Species Act does is it requires every single federal agency to do Section 7 consultations, or this process, it's what it's called, Section 7 consultation, whenever they take an action, whenever they carry out an agency action. And for our purposes, under the ESA, agency action is defined really broadly as sort of anything an agency either sort of carries out of its own volition or anything they authorize or fund. So just under FIFRA, right, that is clearly going to cover a lot of different actions. EPA takes numerous agency actions under FIFRA every year, from registering pesticides, right, from registering new active ingredients to registering new uses or products, to modifying existing registrations, to issuing sort of different components of their re-registration process. There is a lot that EPA does under FIFRA. And for each and every one of those actions, EPA is expected to go through Section 7 consultation. This can be a very lengthy process. Essentially, if EPA makes a determination that its action is likely to adversely affect a species, and that could be any listed species, plant, animal, fish, insect, whatever, then EPA needs to reach out to either Fish and Wildlife Service or the National Marine Fisheries Service to engage in formal consultation. This consultation process usually results, in fact, is required to result in the creation of a legal document called a biological opinion, or BIOP. And that's where whichever service is consulting, and usually it's going to be Fish and Wildlife Service. Fish and Wildlife Service is responsible for sort of all terrestrial and freshwater organisms, whereas National Marine Fisheries Service is responsible for marine organisms. But it's through this biological opinion that the service is going to say whether or not what the action that the agency is taking is likely to increase the chance that a species could go extinct. If they make that finding that whatever action the agency is proposing to take could significantly increase the chance that a species could go extinct, then in the biological opinion, the services are also going to make suggestions to the agency on ways that they could, still achieve the goal of their action, but sort of alternative ways they could carry out that action that's going to reduce harm to species. And one of the big challenges for EPA really has been fully carrying out these Section 7 consultations, in part because EPA takes so many actions under FIFRA every year. So just that on itself means that there's a considerable amount of workload involved. When you're talking about pesticide actions, most likely, it's more often than not that EPA is going to sort of make that finding that it's possible that whatever action it's taking under FIFRA could adversely affect a species, therefore sort of triggering, right, that need to do the formal consultation process. And then on top of that, many of EPA's, right, FIFRA actions cover a variety of states. You could be talking about, say, something like reapproving glyphosate, which is registered in all 50 states. That's a pretty significant undertaking as far as consultation goes, because it requires the services to consider, impacts to listed species across all 50 states. It's a big undertaking. So it has been a challenge for EPA to meet fully those ESA requirements in the past. And that has led, particularly in recent years, to just a series of mounting lawsuits, typically filed by environmental groups, challenging EPA's FIFRA decisions for failure to engage in that mandatory ESA Section 7 consultation. And because of the history of how courts have interpreted the language of the ESA, pretty much if an agency doesn't do Section 7 consultation, they're going to either, at best, send whatever action it is back to the agency with directions to consult, sometimes with a timeline attached. And at worst, they're going to vacate the agency's action until the ESA can be fully complied with. So this is sort of what this new policy is aimed at addressing. And really broadly, what EPA is trying to do is to adopt what they're calling early mitigations, which are really boiling down to new restrictions that are going to be added to pesticide labels in an attempt to reduce impacts to species, so that when EPA gets to those future Section 7 consultations, whether it's maybe registering a new use of a pesticide that's already, out there and available, or whether they're re-registering a pesticide, going through and doing that every 15 years re-registration requirement, that when they get to future Section 7 consultations, the hope is that these early mitigations, these new restrictions, will reduce the likelihood that they will kind of have those findings that that whatever action EPA is taking is going to significantly increase the likelihood that a species could go extinct, and therefore reduce possible future mitigations. So it's somewhat complex. It took me a second to fully appreciate what the agency was trying to do. So what they're doing is hoping that by adopting additional mitigations and use restrictions sort of now on the front end, in the future, when EPA gets to some of these Section 7 consultation processes, it will result in fewer restrictions later on. So very, very broadly, EPA is developing these early mitigations in kind of two primary ways. Their first approach is to group together different pesticides, and they're doing this very broadly. So we're getting an herbicide grouping, an insecticide grouping, a rodenticide grouping, and I would expect a fungicide grouping. And they're going to develop early mitigations that will apply kind of across that entire group. And then they're also taking a more tailored approach where they're identifying species that they believe are particularly vulnerable to pesticide impacts, and then tailoring some mitigation and some pesticide use restrictions specifically to reduce harm to those species. So they're taking that sort of broad grouping approach and then that more narrow tailored approach. What we know so far of this broad, right, grouping approach is the draft herbicide strategy. So this was issued last year. It was open for public comment last fall. The Division of Agriculture at the University of Arkansas actually submitted some comments. So I highly recommend reading those. It raised some very good points. So what this draft herbicide strategy is, it's again a draft of sort of the EPA's proposal for how it's going to treat that herbicide grouping under this new ESA FIFRA policy. And what this draft strategy did was outline the different early mitigations that EPA is expecting to include, again, on all herbicide labels. We should expect to see these mitigations pop up on most, if not all, herbicide labels. These early mitigations fall into kind of two general categories. We've seen mitigations that are aimed at reducing pesticide spray drift, and then mitigations that are aimed at reducing pesticide runoff and erosion. Most of these mitigation measures, if EPA finds that they're going to be necessary across an entire pesticide use area, they're going to be included on the product's general label. So I expect that we are going to see these appear on the general label. It is possible that we could see some geographically specific mitigations under the draft herbicide strategy as well. And for those, we're going to see those posted onto EPA's website, Bulletins Live 2. So if you haven't visited Bulletins Live 2, this is where EPA puts sort of its geographically specific pesticide restrictions. Those get incorporated into the pesticides label with usually some language instructing applicators, and users to go and check out Bulletins Live 2. So I would say that going forward, under this policy, Bulletins Live 2 is going to be heavily relied on. So if it's something that, you're not already familiar with, I highly recommend just going and start noodling around that website, making sure you understand how it works. So what we are seeing as far as the mitigations go in the draft herbicide strategy, I think the spray drift mitigations are fairly straightforward, just sort of in regard to what you would expect to see. The spray drift mitigations sort of include additional buffer requirements, right? Like windbreaks, hedgerows, hooded sprayers have all been brought up, sort of depending on application rate reduction and the level of risk. So primarily under this draft herbicide strategy, we're seeing spray drift mitigations in the form of buffer requirements. When it comes to the runoff and erosion mitigations, that's a little bit trickier. If you've heard anything about a mitigation menu or a pick list of mitigations, that's where this is coming from. It's coming specifically from how EPA is proposing to sort of apply these runoff and erosion mitigations under the draft herbicide strategy. And I'm going to do my best to explain this. I've explained this several times already, and people have said they mostly understand it. It still is slightly confusing to me. I feel like I'm describing like a math word problem. And I'm a lawyer and we don't like math. So, I'm going to do my best here. Essentially, what EPA is proposing to do is to outline a menu of different mitigations, different activities that EPA believes are going to be helpful to, reduce runoff and erosion from pesticide applications. And they've kind of highlighted the different activities they want to include. So we're seeing weather-based restrictions, different methods of application, different infield management activities on fields that are adjacent to sprayed fields, activities to increase water retention, that sort of thing. EPA has identified all those. And what they plan to do is put them in sort of a menu, right? That mitigation menu. And for each activity, they will assign a sort of numerical value. Maybe a weather-based restriction is 2 points, maybe a kind of infield management activity is 5 points. And instead of sort of dictating what activities pesticide applicators and farmers should be adopting, what they're going to do instead is on the herbicide label, they're going to say for runoff and erosion mitigation, you need to maybe achieve 7 points. So then if you are the applicator, you're going to go to that menu and you're going to say, okay, I need to get to 7 points. Well, this activity here is 3 points. This activity here is 4 points. I think both these activities will work well for this particular field. So we're going to go ahead and do that. So the idea behind this is, that farmers, pesticide applicators, they have a much better sense of the on-the-ground conditions than EPA will. And this is sort of meant to give farmers a little bit of an option in what they would like to do. There was a memorandum of understanding that EPA issued between itself and USDA NRCS, sort of allowing, some of the activities that farmers may already be doing as part of one of NRCS's voluntary conservation programs. Some of those activities are going to apply to this mitigation menu. So, maybe you're already doing some kind of in-field management as part of one of the voluntary conservation programs, and maybe, that's enough to get you to 5 points already. So then all you need to do would be maybe to find something that gets you to 7 points, maybe something else. So we are going to do our best at the center to kind of help provide updates once we have a better idea of what programs are going to be included, what activities specifically will be included there. But that's an important piece to know, is that at least at this point, EPA is planning on allowing, some of those voluntary conservation activities that farmers may already be doing to count towards this mitigation menu point system kind of scheme here. So this is what we're seeing in the draft herbicide strategy. We're expecting to see a final version of this year, and I'll talk about the specific dates in a moment. I want to turn first, though, and talk about the Vulnerable Species Pilot Program, or the VSPP, or the VSP, because all pilot programs eventually drop the pilot and just become programs, right? At least that's the goal. So this is the more tailored approach that EPA is taking. So under the Vulnerable Species Pilot Program, EPA has identified at this moment, there's about 27 species that EPA considers as particularly vulnerable to pesticides. And through this program, EPA is then sort of for each of those species tailoring mitigation measures to be added to different pesticide labels to reduce pesticide impacts to the species identified under this program. So whereas, the herbicide strategy was sort of identifying mitigation measures that are going to be applied broadly across all herbicides, this is sort of identifying mitigation measures to help these species, and then those mitigation measures will be incorporated into labels for pesticides that are going to be applied in areas where these species are found. So under the VSP program, we are seeing kind of two broad categories. We're seeing avoidance mitigation and minimization mitigation. So the avoidance mitigation, if you're seeing sort of language from EPA saying, hey, we think this area might be under an avoidance mitigation, that means that EPA thinks that that's going to be an area where pesticide applications could be basically entirely prohibited. If you heard something last summer about, right, like there were rumblings last summer that possibly EPA was going to prohibit pesticide applications in Oregon's Willamette Valley. That comes from this. As far as I know, those were just rumors that got kind of walked back. That's unsurprising because Oregon's Willamette Valley is a huge agricultural region for Oregon. So that got kind of walked back and minimized. But kind of the idea was that one of the species identified in this Vulnerable Species Pilot Program, the butterfly that was found primarily in Oregon's Willamette Valley, and as part of this program, EPA was proposing an avoidance mitigation. So again, an area where pesticide application would be not allowed at all. Minimization mitigations, these are going to be areas where pesticide applications will continue to be allowed, but with increased restrictions, mostly focusing on reducing spray drift and runoff and erosion. And then again, like I said, this is where we're going to see Bulletins Live 2 be relied on very, very heavily. All of the VSPP mitigations are geographically specific, which means they're not going to be incorporated into language in the general label. They are going to be put up on Bulletins Live 2. So for applicators, it's going to be really important, if you're going to stay in compliance with the label, it's going to be really important to check Bulletins Live 2 and make sure there's no active bulletins in your area, especially as we start seeing this program get rolled out more and more. So, like I said, the VSPP, they're proposing new restrictions on pesticide labels to reduce spray drift, to reduce runoff and erosion. For spray drift, once again, it's pretty straightforward. It's what you would expect to see: additional spray drift buffers, perhaps even prohibitions on application methods or droplet sizes. That's fairly straightforward. And then fortunately for the runoff and erosion mitigations, at least here, we're not seeing that mitigation menu come up again. So no more word problems. Instead, they're sort of saying that we can expect to see additional restrictions on applications when soil is saturated, when rain's in the forecast, and then maybe some additional land use practices could be required there. And again, these are all things that we would expect to see under Bulletins Live 2, and these are things that we would expect to see be geographically specific. We did get a brief update on the VSPP last November, very brief. I think it was like 6 pages long. And primarily that update was meant to address some of the comments that EPA had received during the comment period for the VSPP, which was again last year. And I would say kind of the primary takeaways from that update are, first, that EPA is planning to improve species maps for the species that it's including in the VSPP. That's critically important. Part of why, I said we had those rumors last summer that possibly all of Oregon's Willamette Valley, we could see, huge prohibitions on spraying there. That is partially because EPA was looking at an outdated map for the butterfly that was sort of at issue in that specific kind of area. And part of that is because EPA is relying on species maps from Fish and Wildlife Service and the National Marine Fisheries Service. And those species maps are sometimes really great, really detailed, and sometimes they are just descriptions of the habitat that species is found in. So getting more specific species maps is really, really important. And I do like to mention, part of why some of those maps from Fish and Wildlife Service are great, and part of why some of them aren't, is because, it takes a certain amount of resources, time, money, manpower to go out and actually figure out, okay, where is this species located? It might get as granular as needing to go out and count species. And when you're talking about, there's over 1,000 species listed under the ESA, some of the maps are going to be better than others. So it's very, very good that EPA is saying that they are working to better improve those maps for the species included in the VSPP, because that's going to be really helpful for them to best tailor the mitigation measures that they're going to be issuing under this program. The other kind of big takeaway I got from this update is that EPA is planning to clarify some possible exemptions from the VSPP, as well as revisit how it selects vulnerable species. And then it's also going to work to develop a more consistent approach to reducing pesticide exposure. So that's certainly good information for us. I'm personally keeping a weather eye out for when we're going to get an update on this one, specifically with regard to those possible exemptions. Right now, I haven't really seen any details on that, but again, as soon as we have them, I'll be working to make that information available. And then just finally, as far as deadlines go, EPA is planning to provide further updates on the VSPP by fall of this year, including whether or not they will be adding any more species to this program. And there are a number of species that are currently listed under the VSPP that are found in Arkansas. So the American burying beetle is one, the Ozark cavefish is another, and there are a couple others as well. So this is something that I expect will impact applicators in this area. So then finally, like I said, I want to just kind of leave you guys on what we know as far as kind of the next steps that EPA is planning to take. So first, EPA has said that it plans to issue a final draft of the herbicide strategy by the end of August of this year. So sometime this summer, we should get a final draft of the herbicide strategy. And I would expect after that is when we're going to start seeing some of those restrictions appear on herbicide labels. Additionally, EPA plans to issue a draft of the insecticide strategy by the end of July of this year. So sometime in July, we should be getting that. It's really unclear at this moment what that strategy is going to look like, but I expect it will be similar to the herbicide strategy, at least in some of its structure. So, that's sort of the next big thing that we're waiting on, right? Is that draft insecticide strategy. As I said, EPA has sort of set itself a deadline for sometime this fall to give an update on the VSPP, including whether or not it's going to be expanding the program to include more than those initial 27 species. And then just the final note I want to leave you all on is that really at this moment, it is unclear when more of these mitigations will begin appearing on pesticide labels. I think that for the VSPP, we can expect to see more bulletins added to Bulletins Live 2 sort of as EPA finalizes them, which again really means, I want to stress that it's going to be important to stay in compliance with some of these labels. If a label says that you need to check Bulletins Live 2 before applying, that is going to be very important to do. And then otherwise, as far as when are we going to start seeing some of these herbicide strategy mitigations appear? I don't know, but I would hazard a guess at some time after the draft herbicide strategy is issued. And again, it's a little unclear to me what the timeline is going to be to start including language in the general labels. I imagine that's going to be an undertaking in and of itself, but I expect that sometime after this final version is issued is when we'll start seeing that happen. So that is what we know about EPA's ESA FIFRA policy so far. I'm going to put my contact information up on the screen and open it up for any questions that you might have at this point in time.
Thank you, Bridget. That's a lot more to look at.
It's a lot of information.
Yeah, thank you very much. Any questions for Bridget on the ESA rules, regulations coming at us? I think Bridget, my question, comment. So the herbicide strategy, the insecticide strategy, and there'll be a fungicide, those are kind of broad, it looks like, in my opinion, and then the BSP, the SBP, whatever it's going to be called, is more specific. Because we those things are going to work hand in hand, I guess, to go on future labels, and then is this for future products registered? When products are re-registered, are we going to cross these thresholds, or even products that are already registered? Can they, can it be challenging to have to come back and cross some of these thresholds?
Yeah, so I would say you're correct that the kind of this herbicide, insecticide, fungicide, rodenticide, these plans are going to be much more broad, whereas the VSPP is going to be more tailored. Unclear when we're going to start seeing them appear on labels, but yes, kind of the point, at least what EPA has said, they're trying to add these restrictions on the front end, and it unclear to me whether they're going to do it as they're re-registering pesticides or registering new pesticides. But yes, the idea is that by adding these restrictions on the front end, when in the future EPA consults, does that ESA Section 7 consultation for these pesticides, either when they're registering a new use or maybe re-registering a pesticide, or even some of these pesticides have court-ordered deadlines for when EPA has to complete ESA consultation, that with these additional mitigations, the consultation will result ultimately in few to no additional restrictions. Does that answer your question? I know this is such a strange and weird process. It's sort of trying to do something on the front end as opposed to the back end.
I think that's kind of how over the last couple months and hearing back, listening to you and reading some of the stuff from the EPA, that's kind of the idea. EPA is trying to get in front of this. I think it's something we're going to face. We're going to be dealing with it from now on. And so if we want to be able to continue to use these products, EPA is going to have to do these things to get in front of the core challenge, where it's not pulled out from underneath us at the last minute or something like that. Because as you can see with the dicamba label, that can happen pretty easily if these things aren't met. So thank you, Bridget. I think that's how I understand it. And hope anyone else have any questions for Bridget?
Like I said earlier, if someone has a question later on, or if you would like to talk about this more in depth, do feel free to reach out to me, and I will do my best to answer your questions and help you navigate this.
Okay, thank you very much.
All right, thank you.
Good day. think good for all of us to hear and maybe be able to answer someone's questions, if you get phone calls like I do about what's going on. So that's all we had on the agenda for the day. Anyone have any other business to come before the board today?
Mr. Chairman, could I have a quick minute here? I just want to address the board real quick, so. First of all, I want to thank everybody for showing up today. It's just really an excellent turnout for a board this big. We really appreciate your service. I hope you're happy with the way we're administering your business. Some of you are new. I hope you've kind of gotten into the groove of things. We had a couple of really good, smooth meetings. And again, I hope you're satisfied with that and with staff. None of that happens without staff. And I just want to recognize all the people in the background that make this happen. You know, sometimes state employees get a bad rap, but I can promise you the staff working for you and for this department, that they're working every day. And we keep asking them to do more and they just keep doing it. So I do want to recognize them. And I want to offer you, if you have any questions, any recommendations, any suggestions, call me, text me, let me know. We'll incorporate that into how we conduct and administer your meetings. And a little bit of a heads up, I think, you know, we had several years of high pesticide complaints. Last year, our complaints were down, but I do think the stage has been set possibly for this year for those complaints to go back up. My concern are gonna be supply issues with that February 6th in motion cutoff. So that being said, come the fall, we may be having some bigger meetings, some more in-depth, longer meetings. So just be aware that could be coming, and we could always get a petition for rulemaking. I have no indication that's coming, but it could happen. So for the most part, standard business, we've been conducting that through committees and bringing it to you all like we did today, and it runs really smooth. But anything outside of that, you know, a petition for rulemaking, something you need to hear, a big case that has a hearing is going to require full board meetings, so those could be coming as well. So, and again, I'm standing here now. If you have any questions for me now, if not, call me if you need to. But other than that, thank you, and thanks staff. They really did a great job. So, yes, sir.
You brought up what's in the pipeline and potential problems. Have we talked to retailers? What are they saying?
I have not heard. I have heard through the grapevine, through a couple of retailers that had orders in, but they didn't purchase them yet, for whatever reason. And now with that February 6th cutoff with what's in the pipeline, they're concerned that they may not be able to get their orders filled in order to fill the orders they have. So that's just something I've heard. It makes sense to me. I think it's probably gonna happen somewhat. So y'all may have more information about that than I do. Yes, sir.
To reiterate what Reynolds said, and to you, I spoke with a couple of suppliers in eastern Arkansas, and they are under the impression, one with Helena and one with Nutria, that there will not be enough of the OTT product. And concern is just what you said.
Correct. We all know what the alternative is, and the possibility that could happen. So, we're bracing ourselves. It doesn't happen, but we're anticipating our complaints going up this year, and we'll manage them as best we can. So, any more questions?
Does the plant board have any control over price gouging? Cause I've even seen that on the local level. I mean, they've already got it, they got it paid for, and all of a sudden they quote one price and they're like, well, if you want it, it's gonna be 50% more. I mean, that happened to me.
We really don't have a role in that at all. So, I haven't heard that yet, but doesn't surprise me. But
And
no,
that, you
that
know,
would not be.
that even happened like when the first ruling was out on Liberty glufosinate, like price went up overnight 68%, you know, just because you had no other option. So just gouging is one of the things that hurts farmers. We're already taking on the chin many other ways, so.
That does not fall into the Department of Ag, as I understand it. You know, I can ask, but I'm sure it doesn't, and
And I assume, I mean, this is a federal ruling, so there's nothing state as we can issue like an emergency, what do they call it, 20C or anything like that to.
No, sir, nothing we can do.
Cause to me, there's a potential for much more environmental issues by not having the safe product on the market than by having it.
I don't disagree, and I started to bring up the question to Bridget, you know, is it possible EPA could revise that February 6th pipeline cutoff date? I don't know that they can, and if they did, they may trigger an immediate challenge, I don't know, but that would be an EPA decision. And as far as I understand it, we don't have an opportunity to address it at the state level. Thank y'all, appreciate your service.
Thank you.
Thank you, appreciate it.
Any other business for the board today? The last thing we have to do is set a meeting for our next quarterly board meeting, to be in June. And probably, kind of stick to earlier in the month, you can get that full off. That first week, the Thursday, the 7th, I don't know, what that looks like. Anyway.
First is 6th.
Thursday sounds good for me. I'll have a conflict.
Yeah.
Okay, we'll have it scheduled for 9:30 Thursday, June 6th. Forward to seeing everyone then. There's no other business. I'll call this meeting adjourned. Thank you. Yeah.
Recording stopped.